All right, welcome back. Welcome back. Now, of course, today we expected that Supreme Court ruling, and the judges yesterday retreated with the researchers, joined up in what they're calling a judges' conference. That was yesterday to finalize on their verdict. Before the judges asked questions on whether fresh nomination should have preceded a fresh poll, whether the withdrawal of NASA leader Raila Odinga should have led to the cancellation of the election, whether failure to conduct elections in 25 constituencies disenfranchised voters, and whether the right to vote was abdicated as witnessed through a low voter turnout of only 38.8%. Now, the ruling could go one of, of course, there's a debate on this with my panelists, three broad ways. First, they could invalidate the presidential polls and order an election within 6 days. Second, the judges could throw out the petition, effectively upholding President Uhuru Kenyatta's victory. Thus, then the system will follow according to the assumption of office, and then they could uphold. There is also one where they could uphold the presidential victory, but note concerns of any anomalies presented during evidence submission. That is what we have. What do you people think are the possible scenarios? Are they three? Are they two? Or are they, as Vincent said, case studies? We'll start with you, George.
Well, the verdict of a court, basically the decision of the court, will be from past experience. Either judges on one side that form majority, and we have the minority on the other side who otherwise give dissenting decisions. When that happens, then the ones that validate the decision in terms of either there is a pronouncement or a declaration that the declaration of President-elect was right or wrong in court will depend on the numbers. So basically it's about numbers here. From the conduct of the judges at the hearing, all decisions in terms of rulings that were done to include so-and-so as amicus or not, interested parties or servers and all that, including the prayers for the documentation that was had been requested by the petitioners, was all unanimous. So it means therefore there was a level of consultation. It was basically consultative towards making those rulings, and we think that's a good environment in which to work. But don't forget that towards the nullification of August 8 elections, again, there was unanimity in the rulings, but in the final decision there was a split. So what then is the possible scenario, like you've put it? One is a unified decision and a unified decision where the dissenting judges will give their decisions. I think also that the content of this petition was not as detailed, with many facets in terms of the areas of discourse before court. I don't think it was as wide as it was in the 8th August presidential petition. The reason for that is because the narrative slightly changed, personalities slightly changed, and therefore you realize also the legal content in the petition was slightly miffed or reduced. And therefore I do think that they may not even give the summarized version of the decision. They may struggle to give a wider decision, or even if they give a summarized decision, they may give reasons slightly with more content as opposed to what they did last time. Again, what will be interesting for Kenyans to understand also is that in the event, because there are 6, ordinarily they are supposed to be an odd number, so that it's very easy to get a majority. But now there are 6. Because there are 6, it is highly likely also, given the precedent set in the 8th August election and some things that still went wrong, notwithstanding that was a repeat, they go for a split, meaning an equal split, meaning that 3 are for and 3 are for not. In such a situation, therefore, it's as good as there was no petition, meaning the Supreme Court did not return a verdict, because one side and the other side are equal. You see, if there's a vote and the vote is equal, then it's good as if there's no vote. And therefore, what it means is that the election still stands. So the 2 scenarios an election can stand in the circumstances we're in is either a pronouncement, direct pronouncement in unanimity, or a majority that the election was free, fair, and credible, or it meets the threshold, or to some extent it did. The other one is a tie of the 3-3. The other possible is the one we've already enjoyed before, a nullification. I must say we've enjoyed a nullification because then we went to these other possible scenarios. Suffice it to say that in all these, then we can then reduce them into two: the nullification, or to sustain that the president-elect can proceed and be sworn in.
And
one thing, Section 26 of the Supreme Court rules provides the scenario that Wakibi has brought about. One is a dismissal of the petition as a whole. Then another one is invalidation of the presidential win, for that matter. When you look at those two scenarios, without weighing so much to what maybe my colleague has pointed out, the most important thing, according to me, in this petition is that we're going to set the threshold, the legal threshold, on most of the issues. It's going to give a closure to some of the issues that have been canvassed earlier on. One of the issues is about the meaning of fresh election. The Supreme Court in 2013 tried to give the meaning between various meanings of, or the various definition of a fresh election. Once this Supreme Court makes its own detailed judgment, which I expect at this time round, because the issues raised are actually very few. The issues about what's a fresh nomination, what a fresh election is all about, then the issues of voter turnout, if a minimum number of voter turnouts affects the election. We've seen case studies from Burkina Faso, Mali, what the content or what is the position, the legal position elsewhere about voter turnout more so in terms of a repeat election. What we expect from most of this time round from the Supreme Court, it should set in place a legal threshold for those issues that have been raised. And I expect probably two things, apart from dismissal and either upholding or invalidation of the election, is for example the issue about failure to vote in 25 constituencies. What is the legal position, and what is the incentive to the part of the beneficiary if one party, for example, makes it uses illegitimate means to legitimize a presidential win? What is the effect? Probably at this moment in time, the Supreme Court should actually secure this opportunity to make a sound judgment or orders with regards to individuals who try, for example, to use illegitimate means to illegitimize an election. Then the rights of the voters. The rights of the voters in the progressive. What Akim also had pointed out, we have a very progressive constitution, and Article 38, as well together with the various provisions in terms of the Bill of Rights, together with the section Article 81 and 83 of the roles of IBC. If one party, for example, or a stakeholder within the election process tries to put in place infrastructure or mechanisms to differentialize the voters, what should the Supreme Court, for example, what is the legal position? In Africa, we have not set up in place jurisprudence to be able to guide the development of law to that extent. So I think as a people, let us not look at only the invalidation of the election and maybe the dismissal of the same. Let us look also, or upholding of the same. Let us look at various other issues. More so, I think the jurisprudence from the Supreme Court is what will really guide this country moving forth. Because elections is what probably after today, the election issues will be over, but we still have other elections to come in future. So the law should be developed to an extent that it should be able to guide, put in place mechanisms, and also the law should be punitive in a particular way. We look at a definition of maybe the issue of withdrawal and abandoning of the electoral process. I know the right to contest is a personal right, but it should also put in place mechanisms that are punitive to the extent that you don't abandon an election process in the middle for purposes of maybe illegitimizing the whole process or wasting, for example, wasting taxpayers' resources. Then the issues about if you abandon, what will be the effect? More so on the issues of nomination, because there is a cost, there is a budgetary expectation on the part of the taxpayers. What is the legitimate expectation on the part of the taxpayers? And when you look at the jurisprudence on the part of on the part of the election system. We've seen, unlike before, right now the amendment, the elections 2017 election amendment has put in place, the amendment of section 83 has put in place the issues of non-compliance on the part of maybe IBC, or the part of IBC should not be construed as a reason to invalidate an election, and is actually putting the Supreme Court in a very tight fix, because later on in the other elections to come, what will be the position? What will be the legal position on specifically the issue of non-compliance on the part of? Are you putting the Election Commission, the IBC and Supreme Court as loggerheads? Because some of these issues, also bearing in mind the timing of the amendment, of the elections amendment, and the failure of the president to sign, but in real sense, the Article 115 of the Constitution, the laws are now. The bill is now an act of parliament, just by lapse of time. What is the position? Actually, I think probably this time round, the Supreme Court should put its legal mind into actually try to exercise it in a sense that what will be the legal position of the amendment laws that have been now gazetted. Once that is settled out, then the issues of whether we uphold, whether we dismiss or uphold, I think that is neither here nor there. But for me, it is about the future, because if you look at section 26, it gives those two scenarios, but says the Supreme Court can also make necessary orders as it may deem fit. You get, when it says deems fit, then it gives rooms to other interpretation. So I think that is basically what we should expect.
All right, just take a look, even as I bring you in, Vincent. Is one of the lawyers, Julie Soweto, say that the judges should make the ruling so they shut the door to darkness. She was, of course, asking for the petitioners, and President Uhuru Kenyatta's lawyer, Fred Ngatia, talked about, ask the judges to look at the common good of the nation. Now, so when this ruling is being made, I mean, what are some of the things that the judge is looking at? Of course, that's what people have been asking. Is it, as the headline says there in the nation, does it come down to the law, or is it public good?
In my view, and that's why I allowed my two colleagues to go ahead, judgments are also not given in a vacuum. So I appreciate the things that the Supreme Court judges ought to clear in terms of law, those issues of nomination, withdrawal, all those things. That's good for the purposes of ensuring that we are legally clear. Willis, one of the advantages of building good institutions and strengthening them is that in 2013, the unanimous decision of the Supreme Court was condemned by those who had petitioned the court to annul the result. And you remember, for over 4 years, even discussions was it should not be something that anyone should quote. You are in this country. But come 2017, the premise which the NASA presidential candidate and running mate stepped out of or boycotted this election was on 290 and of the judgment that in the event one abandons, you go back to fresh nomination. That judgment, which was not popular, all that became all of a sudden an anchor, even politically, for political discourse. That is the benefit of strengthening and building good institutions, because it will benefit anyone at any one time. So what I would point out is that I would really see that the Supreme Court said in their judgment that if you go back to an election and you don't or comply with the Constitution and the law, and this was even said by the CJ, we will actually annul we will do it. We'll make the same decision again. So in my view is that if truly there were things that were not done right, the integrity demands is that we be truthful through and through. But also we should appreciate that that can only happen also if we, the people, are committed to the rule of law through and through. Because one of the reasons why the elections did not take place in some of the areas was not only just because of politicians, also the members of the public participated in that process. So that now calls in the balance between the law and what is in the public interest. But I don't think it will be right for the judiciary or the Supreme Court to put as in convenience and circumstantial developments ahead of the fidelity to the law, because they have taken an oath that they will act without impartiality, without ill will, and that they will uphold and promote the Constitution. So, in my view, as much as we are in a context, but I will raise the importance of sticking to the rule of law and upholding the Constitution ahead of everything, because everybody is obligated to do that.
All right, of course, gentlemen, we are coming up, running out of time, so I'll just allow us to make our final comments.
Good. I think as a society, we must admit our obligations to each other. The first obligation to each other is self-preservation. When you preserve yourself, you create boundaries and you delineate your space. The next person, therefore, starts somewhere. You see, in your land, at home, if you have a plot, it stops where the beacon is. You therefore know that from there onwards, that's somebody's space. So then, as we self-preserve our space, the next person, the next space which you can't occupy ad infinitum, the other person occupies. And therefore, we need to know when our rights start and stop, because then the next person's right starts and stops from there too. It's all a cocktail of relationship and a web. But remember that as you do that and as you destroy other people's property, the same environment you hatch comes back to you. Because, like I said, it's a web of and a cocktail of societal relationships. So I think if we exercise restraint, even as we expect the decision of the Supreme Court, life must move on somewhat.
We do not have a legal nor a constitutional problem. Ours is a political one. Political problems are given political answers, and they should be done within the confines of the Constitution. Number two is that I think it is time we audit our Constitution, see areas that there are gaps, and actually address them. Those that can be done within the legislature, let them be done. Those that require referendum, let them be done. And then finally, is that Martin Luther once said that light, it's only light that can drive out darkness. It is only love that can remove hate. And if we practice politics of hate and division, the dividends or the fruits are evident in our midst. I think we need political hygiene. We need to rise beyond ethnic mobilization to really mobilizing people on the greater good and mobilizing people on aspirations. The Constitution in its preamble acknowledges the aspirations of all Kenyans. So I think it is important to ask ourselves, how do we ensure that those aspirations are able to be canvassed within the confines of the governance structures, both politically and economically, so that we can live what our national anthem tells us, that plenty be found within the borders of Kenya.
Actually, one great writer from Nigeria called Okey Ndibe, in his famous book or seminal book called The Trouble of Nigeria, he said the trouble with Nigeria is not about the air, land, it's not about its crops, it's not about anything, but it's about the leadership. What faces this country is a leadership crisis. And at the moment, our leaders will sit down, agree to talk, but talk or have a dialogue within the confines, the strict confines of the Constitution, then we will be able to solve most, if not all, of our issues through dialogue, but through the confines of the Constitution. Lastly, with the Supreme Court, I expect two things. One is to develop the law, because our Constitution as it is at the moment is so much about novelty, to the extent that some of the issues that were legislated or were written were drafted within the Constitution were things we did not expect. Our people have become so litigious in nature, and to solve some of the issues, probably the Supreme Court should give detailed and extremely well-founded judgment, so that some of the issues that may come in future should be addressed, so that every other election should not be an issue of going to the Supreme Court, because the court, as you've seen at this moment in time, has wasted so much. To our politicians, I think it is time to this premium that you have given to our politician. At one time I was in Norway. When you are in Norway during the election process, you don't even know that there's an election going on. If you look at elections in Germany, people vote and go. Actually, the returning officers are all volunteers. If you're going to give so much premium to our politicians, because today you think the only thing a politician can do is a panacea to all your problems. Today he's an economist, he's a lawyer, he's an advisor. A politician in this country has become like he's everything, can do everything. I think when we reduce the premiums to the political office, that is the time we shall wake up and hold this country to a better position. I think that's all.
All right, thank you very much, Danson Riziki, Vincent Kimosop, and also George Kipi for all your comments. Of course, we must also mention that we had been expecting Jane Divo, but unfortunately she was not able to be with us this morning. It's an important day, the verdict D-Day, as it is written down there. We're waiting for the Supreme Court ruling, and also more discourse happening online about the slum killings, and more reports and questions are still being asked about that. We're going to be covering that more extensively later on Citizen Extra, even as we wait for that. Citizen Television's comprehensive coverage